Welcome to Litigation in Practice, brought to you by Solomonic. Solomonic is a litigation data intelligence platform used by over 11,000 litigation professionals to track the market, analyze how cases have been decided, and better understand trends in disputes. This is a series where we bring together data-led insight with real practitioner perspectives, and we're delighted to have you with us. Today, we'll be focusing on sports disputes, so an area that spans everything from personal injury claims and regulatory challenges to sponsorship disputes, insolvency actions, and high-value commercial litigation. Recent Solomonic analysis shows sports-related litigation is becoming a more visible feature of the high court landscape. So since 2020, we've recorded more than 135 sports-related disputes, with annual volumes rising steadily from just 6 claims in 2020 to a peak of 40 in 2024. Now, while sport is often associated with competition on the pitch, the legal issues surrounding clubs, governing bodies, investors, and sponsors, as well as athletes, are becoming increasingly complex. I'm joined today by 3 leading practitioners in this space: Rhodri Thomas, Alex Askew, and Chris Morris. I'll hand over to each of them now to briefly introduce themselves, and I am excited to have them here with us today.
My name's Rhodri Thomas. I'm a partner at Freshfields, where I'm head of the sports disputes group. I've been doing sports disputes for 21 years now, and I am an arbitrator in the Basketball Arbitral Tribunal. I act for different football clubs, basketball clubs, different federations, investors in all sorts of sport, from tennis to rugby to sailing to cricket to football, and generally focus on arbitration, litigation, and contentious regulatory disciplinary proceedings.
I'm Alex Askew, and I'm an associate in the litigation and arbitration team at CMS. And my practice focuses on resolving commercial disputes with a particular specialism in handling contentious matters across the sports and entertainment sectors. And within that, we tend to advise a broad spectrum of the stakeholders across that industry. So from governing bodies to clubs, to athletes, investors, media agencies, and broadcasters.
So my name is Chris Morris. I'm a legal director at DLA Piper. I do a real mix of high-value, complex arbitration and litigation with a particular speciality in sports disputes. I've worked on a lot of cases in recent years and spent about 7 or 8 months at the Premier League in-house last year. So I've dealt with quite a lot of football-related issues, but we're seeing disputes arise in all sorts of sports at the moment: football, Formula One, rugby, athletics. There's a real push in terms of sports disputes at the moment. So a very exciting time to be in the sector.
Great, thank you all for joining. Let's start with the landscape. Sports-related disputes appear across a wide range of courts. Personal injury claims account for the largest share, 19% of cases since 2020, perhaps unsurprising given the inherent risks of sporting activity and liability around injuries. The commercial court and general King's Bench, both at 17%, reflect high-value contractual and business disputes. Across all sports, football has attracted the highest volume of disputes. Some of the highest profile cases have centered on football club ownership and investment disputes, such as iconic Sports Eagle Investment LLC v. Texter, while motorsports, which ranks at the second most litigious, has produced major litigation, including Massa v. Formula One Management, arising from the 2008 Formula One World Championship. Horse racing and equestrian disputes, along with rugby, are tied as the third most litigious sports, followed by smaller volumes in sailing and yacht racing, boxing, and golf. At the other end of the spectrum, skiing, paragliding, and cycling, excluding everyday road traffic personal injury claims, rarely feature in high court litigation. The data suggests sport is becoming increasingly commercialized, attracting more complex corporate, financial, and cross-border disputes alongside the more traditional regulatory and sporting issues. From your perspective, how has the sports disputes landscape evolved in recent years?
Yes, it's evolved an awful lot, I think I would say. Probably the biggest stimulus for that change has been regulatory development. So we've seen quite a significant changes to Formula One regulations. In basketball, in the UK, we've seen a complete overhaul of the regulatory regime following High Court litigation between Super League Basketball and the British Basketball Federation. That's still happening now. NBA Europe is going to change the landscape for basketball across Europe, including the UK. And then probably in football is where we've seen the biggest regulatory change. So you have things like in the Premier League, a move away now from the PSR regime to the SCR regime, the squad cost ratio regime. That's going to be a huge change for clubs. We've also seen the introduction of the independent football regulator, which is very significant indeed, I think. And these regulatory changes don't by themselves create disputes, but some of these developments are born from litigation. So, at least part of the reason for introducing a new independent football regulator was to deal with the challenges of the things like the European Super League, which was a very significant piece of sports litigation in the CJU in recent years. Basketball regulatory change was born out of litigation as well. And so some of these regulatory changes will no doubt prompt further disputes. So, it's unlikely that brand new regulations and laws are going to be absolutely perfect. And some participants within sports often want to challenge them. So that's one area I think where we'll see some development from what's been happening recently. They also provide new forum and new opportunities. Some of these changes do for further disputes. I think that's the change in regulatory regime, I think, is a big stimulus for disputes, as well as obviously the growing commercialisation of sport. There's no question that some of the disputes that we're seeing in the landscape are driven by the volume and nature of the diverse investment that has occurred in global sport over the last 5 years. And you see that through, for example, increasing disputes around things like multi-club ownership for football clubs in Europe and in the UK. That's about how people invest in clubs or in groups of clubs. We saw the Manchester City Premier League arbitration over the last couple of years, 2 arbitrations there around associated party rules within the Premier League rules. And, that was about non-discriminatory treatment of different types of funding in football clubs. So making sure that the way in which owners and others invested in football clubs was done in a non-discriminatory way. So you can see how the sort of investment stimulus has an important role in developing the disputes landscape as well.
Thank you, Rhodri. What do you think, Alex?
The sports disputes landscape has changed significantly. And I think there are probably 3 main drivers that are worth highlighting. Before getting into those, I think it's probably worth stepping back briefly. If you look at the trajectory, sports governing bodies used to operate with almost complete autonomy. And Lord Denning famously said back in 1971 that justice in football was often better done by a good layman than a bad lawyer. But I think, that era's over. Once players in clubs started to appreciate the commercial impact of certain rules, challenges were made. And the regulatory framework evolved to require adherence to the rules of natural justice. So proper notice, the right to be heard, the right to legal representation, and the reasons for decisions. So that leads nicely on to the first driver of change. The regulatory environment is expanding. The most prominent example of that in England is the introduction of the independent football regulator. And the IFR brings a licensing regime, an owners, directors and senior executive suitability test, and ongoing notification obligations that are genuinely comparable to financial services style regulation. So clubs now need to map their senior management responsibilities and identify which individuals fall within that regime. And the consequences of an adverse finding can include removal from office or disqualification. So this is a real step change in the governance burden. And it's already generating questions about jurisdiction, the scope of the relationship between the IFR and existing league rules. And it's not just the IFR. We're also seeing competition law being used to challenge the governance structures of sport more broadly. The European Super League litigation is a prime example of that. And that case went all the way through the courts on the basis that those rules amounted to an abuse of dominance and restrictions on competition. Should probably also mention the wave of regulatory enforcement within the Premier League itself. The Manchester City 130 charges case is, pretty extraordinary in its scale and complexity. It's not just a sporting infraction, it's a high stakes administrative law battle. And that case shows that even internal disciplinary machinery of sport is now generating the kind of contested technical legal arguments that you would expect in a regulatory enforcement context. Secondly, we're seeing more disputes driven by employment law. The PGMOL referees litigation is a good example of that. That went all the way to the Supreme Court in 2024, where the court held that the minimum requirements of mutuality of obligation and control were satisfied for referees. And then that case was remitted back to the first-tier tribunal, which gave its decision in May, so only very recently, and found that the referees were not in fact employees, despite the Supreme Court's judgment. And that demonstrates, I think, how the sports disputes landscape continues to grapple with questions about employment status, particularly where we've got regulatory frameworks intersecting with commercial relationships. And then to kind of add to that, the Employment Rights Act 2025 has expanded access to unfair dismissals claims and also removed the compensation cap for high earners. So that really increases the exposure for clubs and the incentive for players, managers, etc., to litigate. Then I think the third driver is the growing commercialisation of sport and how that's generating its own wave of disputes. The inclusion of sports law as arguably a distinct area of practice now reflects the exponential increase over the last 20 years in litigation, and particularly in arbitration related to organised sport. The global sports sponsorship market has been valued at $57 billion and it's expected to reach nearly $90 billion by 2027. So the commercial stakes here really are enormous. And sponsorship in women's sport alone has grown by 38% annually. Despite that, many organisations and athletes are still quite under-resourced on the contractual side. New disputes are emerging in terms of image rights, morality clauses, exclusivity, and termination triggers. We're also continuing to see complex agency disputes, so player versus agent, agent versus agent, where fiduciary duties, secret commissions, conflicts of interest are being tested. It's also worth mentioning the Bosman decision, the high-profile decision, which confirmed that sport and its governing bodies are subject to EU law, and that fundamentally changed the transfer system. So that case opened the floodgates, and we're still seeing its legacy play out. More recently, the Diarra ruling from the ECJ has gone even further than that, fundamentally challenging FIFA's transfer regulations under competition law and freedom of movement principles, which prompted FIFA to reform its rules. And that decision has really redefined the balance between governing body autonomy and the rights of individual players. So the landscape has become more regulated, more commercial, and more litigious, and those trends are accelerating.
What else would you add, Chris?
I think we've seen a real transformation in recent years. There's been an emergence of complex and high-value disputes involving all manner of sports stakeholders, from governing bodies, leagues, teams, sponsors, and broadcasters. And I think what we're seeing very commonly is that sports disputes used to be, in some ways, relatively contained. They wouldn't necessarily be the biggest dispute. They might be resolved fairly quickly. And now a lot of sports disputes that come across our desks are increasingly complex, and they're high value, and they result in really hard-fought litigation, long hearings, and they require large legal teams. And certainly gone are the days, I think, where the biggest sports disputes can be resolved by just a few people being involved. Now you're seeing large teams dealing with disputes over many years, which is a real shift from the past. We're particularly seeing new interventions from competition law challenges with a wider application of law, so not just sort of law that may apply to sports rules and regulations, but other concepts being brought in, and those are becoming central features of sports disputes. And I think probably an overall general trend, without wanting to generalize too much, is that sport has become a major global business, and it's become an asset class in its own right. So as a result, the disputes are increasingly less about what happens on the pitch or the track, and more about who controls the money, who controls the rules, and do the rules work, and who has oversight over things like data and technology. And sort of ironically, in a way, you're now seeing some sports cases becoming of greater and wider legal significance in their own rights. And we've just heard about Felipe Massa's Crashgate case is going to be leapfrogged to the Supreme Court over the issue, or to clarify the law on unlawful means conspiracy, which is a really remarkable feature of recent litigation in the sports sector. And of course, sort of what we're seeing quite a lot of is a completely new disputes landscape with the arrival of the new independent football regulator, in England, which means that we are dealing with a new era of statutory regulation. The IFR has new powers, and there are sure to be a number of disputes in that area for years to come.
That's really helpful context, and it leads nicely into how these disputes are actually being handled in practice. So is arbitration the dominant route for sports disputes, or are we seeing more recourse to litigation?
It's a really interesting question at the moment, because I think the reality is that there are multiple fora in play, and there's a real variety of cases happening that are sort of broadly sports disputes. That's kind of big sort of catch-all term. But I think certainly for sort of disciplinary, eligibility, regulatory disputes, arbitration is the primary means of resolving those disputes. And I think that's going to be the case for years to come. You know, the Court of Arbitration for Sport has a justified position as sort of, some people would say, Supreme Court of Sport for certain disciplinary and regulatory disputes. That's not going to change. I don't see there being any imminent changes to the internal arbitration and disciplinary rules that apply in the case of, you know, major leagues and competitions around the world. Those sort of fixed and are likely to stay like that. But I think what we do see is an interesting choice, really, from other stakeholders in the industry on the more commercial side of sport. So at the moment, we're seeing fairly common trait that sponsorship agreements, for example, will often have London-seated arbitrations, and the rules might be the LCIA rules or the ICC rules that would apply to any disputes in relation to those agreements. But in contrast, many broadcasters and sort of joint venture arrangements in the broadcasting or media sector increasingly have, or traditionally have had, English law clauses and English court jurisdiction clauses, which is different from arbitration. And I think ultimately it depends on what perspective you're looking at. So I think the rules of governing bodies, competitions, and leagues, arbitration feels like a natural fit for them, really. You have experts determining the issues, confidentiality and private hearings is usually a feature that is desired. But by contrast, many commercial parties are quite comfortable with the English courts and are quite comfortable having their disputes heard publicly. And we obviously have an increasingly new development with the introduction of the independent football regulator, who, that regulator has statutory powers under the Football Governance Act, and some disputes under that act will be resolved by the Competition Appeals Tribunal, because that's the entity that's been designated to hear and decide those disputes. But then there are other decisions and acts that the regulator may take which will be subject to judicial review, or could be subject to judicial review, which would take place in the administrative court and in the High Court. So there are different trends depending on where you're looking. But I think it would be very interesting to see whether increased transparency that may come to who can own or run a football club under the Football Governance Act, whether having those disputes playing out in a public forum may have a knock-on impact for other processes. So time will tell on that front. And I think we're all dealing with a new age of regulation that is still working itself out.
What is your perspective, Alex?
Arbitration has obviously traditionally been the default route when it comes to sports disputes, and there are obvious reasons why. It's generally confidential. It can offer specialist decision makers with sports-specific expertise, and it can reduce the reputational fallout of a public dispute. The Court of Arbitration for Sport remains the preeminent institution globally. And to give you a sense of scale, by the end of 2024, a total of 11,554 requests for arbitration and appeals have been filed with CAS since its first case. And the Appeals Arbitration Division, which handles disputes arising from decisions of disciplinary tribunals and sports federations, that accounts for approximately 75% of the CAS workload, with the ordinary division handling around 90%. So that shows you kind of the sense of scale there. But what we're seeing is that picture is shifting. We're seeing an increasing number of claims being brought in the civil courts and employment tribunals. And forum selection is becoming increasingly tactical. So domestically, mechanisms like Rule K in English football continue to handle the bulk of operational disputes, and probably for sensitive disciplinary matters. So take the Tara Moore tennis anti-doping appeals example. Their confidentiality and industry-specific expertise make arbitration the natural choice. However, when the issue is a commercial breach rather than a regulatory rule, the High Court is increasingly becoming the battleground. clear example of that is Macron Sportswear and Blackburn Rovers. It's related to a kit supply agreement, and there the High Court was obviously the forum than a private tribunal. So when significant sums are at stake, the historical premium on privacy can give way generally to a strategic desire for the procedural certainty and the kind of binding precedence of the commercial court. Then looking at the employment side, tribunals can be attractive for claimants because proceedings are public. So that can kind of create reputational pressure on the other side. And because there certain types of compensation are uncapped, particularly in discrimination and whistleblowing claims, we're seeing a real increase in that. At the same time, arbitration is not always available, or it may not be effective for some employment-related claims. And statutory rights may still need to be carefully addressed regardless of the forum. So parties increasingly need to think about strategic implications, publicity, remedies, confidentiality, cost, etc., when choosing a forum. So I think the short answer is arbitration remains central, but it's no longer the default now, and the choice of forum is now generally a strategic decision.
So I think both of those are correct. I think arbitration is still very dominant, especially when you include sort of contentious regulatory investigations and sanctions, and I would include that within sort of sports disputes umbrella. A lot of that comes down to a desire for privacy, both I think among regulators and other participants, whether it's athletes or clubs or investors or sponsors. So I think that's an important part of the attraction to arbitration within sport, but also flexibility. So there's definitely pockets of sports arbitration where there's a genuine advantage to the speed with which arbitration's able to move at, and having specialist judicial panels who are real sports experts, I think provides another benefit. So I think that's absolutely correct that arbitration is still dominant. However, as you say, there is more and more court litigation in sport. So English law governs an enormous proportion of major commercial agreements in sport, whether that's M&A transactions, sponsorship agreements, other commercial partner rights agreements. Often where you have English governing law, you have English jurisdiction clauses. And, this isn't unique to sport, but the English commercial court has, enormous expertise in high value, complex disputes. And so to the extent we're going to see more and more high value, complex disputes in sport as we are, then it means the High Court is very well suited to dealing with those sorts of issues, as well as injunctive relief. I think the High Court offers a lot of favourable options for participants who are seeking effective interim injunctive relief. So maybe a broadcasting deal is being terminated mid-season, or maybe a club is being threatened or being relegated in a particular sport and needs access to very quick, meaningful redress. Often courts can be better positioned to deliver that than arbitration panels. Not always the case, but quite often the case.
So in your opinion, off the back of that, is London a leading forum of choice compared to other venues such as the Court of Arbitration for Sport, so the CAS?
Yeah, I do think London is a leading venue for arbitration. I think again, English law being so prevalent in many contracts is going to help that. But also, I think, again, as sports disputes become more sophisticated, higher value, London has lots to offer, whether it's meaningful sport resolution bodies like Sport Resolution, whether it's arbitration centres like the IDRC, whether it is body of expert sports arbitrators that practice in London. There are lots of reasons why London should remain a very attractive, I think, venue for sports arbitration. Obviously, it won't be the only show in town. The Court of Arbitration for Sport is a very successful arbitration dispute resolution mechanism, and there are good reasons for it being based in Lausanne as it is. And I think, to the extent that sports disputes are global, we're going to see a diversity of venues for resolving those disputes. We don't think it's a bad thing either.
Thank you very much for answering that question. So now on to our last and final question, which is probably the most exciting, where we're looking into the future. Where do you see the next major risks or disputes coming from over the next few years?
Yeah, I think that's a very good question. To the extent that one of the main drivers in sports dispute has been increasing levels of investment, I think as more money flows into women's sport, it seems logical to expect more disputes there. I think we'll see more disputes involving competition law. I've already seen quite a few, as I've already mentioned, the European Super League decision in the ECJ. That's had I think, pretty profound impact on sports disputes. And I think the application of that sort of authority is still being understood by practitioners. And I think there's still a lot of people that want to fully understand the contours and the parameters of that decision. And I think we're going to see further litigation around that. So the application of European and UK competition law to sport is going to be an avenue for further dispute. I think that's a second area. Third area, I would say, I think we might be starting to see the advent of mass claims in sports in the UK, in the EU. Most people are aware of the concussion litigation in football and in rugby in the UK. We're starting to see more disputes pop up in Europe against large regulators such as FIFA, which are essentially mass claims. They currently make up a tiny minority of all the sports disputes we see, but they tend to be large, complex cases. I think we'll see more of those over the next few years. And then the last area I'd probably identify is disputes that relate to the independent football regulator, whether that's sort of internal appeals of decisions of the IFR or appeals that come out of IFR decisions into the Competition Appeal Tribunal. And that's going to be something that's very different. That's going to be, for example, a public forum in which we'll see potentially football clubs engage in disputes against either the regulator, or we might see other affected groups such as fan bodies in public disputes with football regulators, which is quite new and quite different. But as I said, it's a completely brand new avenue for football disputes.
Amazing. Thank you so much. Those are some really great insights, Rhodri. What do you think, Chris?
I think there's a lot that could happen in the next few years, but I think a lot of disputes would arise from the business of sport rather than the sport itself. So the regulation of ownership, the rules that may apply to the use of technology, data, and things like that. I certainly think we're going to see disputes arising from ownership and investment models in sport, particularly in football. We're expecting to see a new wave of cases involving athlete data and AI-generated content and the use of technology on and off the pitch. And there will be a continuation, we expect, of challenges to the decisions that regulators make and the rules that they apply, particularly in areas like financial regulation and similar areas. So I think what we'll see on the commercial side is a continuation of disputes that may look like normal commercial disputes, really. It may relate to the ownership of an entity, of a stadium. We've seen a recent case involving Everton and Burnley that has opened up the potential for follow-on claims for damages against clubs that have been subject to regulatory decisions. I think that's an area that may become much more significant in years to come. Obviously, technology and data is set to be a major battleground for many sectors, not just the sports sector. But I think novel questions such as the use of AI in sports, athletes' data, automated decision making, those issues are already beginning to surface, and I think they will develop in the next few years. And you only need to think about a major sporting event. What happens if the technology malfunctions? Could you see a situation where a technology company ends up being liable for that deficiency or oversight? Who knows? It depends. Is the answer at the moment, but certainly interesting trends to look out for. And I think in terms of regulation as well, we've seen big regulatory disputes play out in recent years, but I think parties in the sports sector will continue to test existing rules. It's about marginal gains, pushing to get the greatest advantage that they can, and we'll need to see more regulation and rules come in to keep pace really with the change that we're seeing in sport and the wider economy. So we'd expect to see more disputes over regulatory rules. And I think particularly interesting will be how the independent football regulator performs in England, whether it achieves its goals, whether that has wider implications for more statutory powers for other sports. So it's a definite case of watch this space with that area, I think.
Amazing. And last but not least, what is your perspective, Alex?
I think we could probably mention, hundreds of the different risks and issues that might affect, but I think probably boil it down to 3 or 4 real points here. First, regulation and governance. The Football Governance Act 2025 is the first overarching statute dealing with the governance of football, and the IFR is still in its early stages. It's begun consultations and is moving towards a staged licensing regime, but we don't yet have settled regulatory practice. The definition of owner under the Act is deliberately broad, and it extends well beyond simple shareholdings to include anyone exercising significant influence or control, so holding more than 25% of votes. And the Secretary of State has the power to amend that definition to capture more complex structures. So that means that the next 2 to 3 years are likely to see boundary testing by clubs and investors across funding transparency, offshore ownership structures, competition law, and kind of heritage protection disputes. So the IFR's reach extends beyond football's own regulatory framework. Action by another regulator to which an individual is subject can also trigger IFR scrutiny, and the threshold of seriousness is not fully defined yet. Second, a big one I think is eligibility and inclusion in women's sports. This remains one of the most complex and sensitive areas. The issues around DSD and intersex traits, transgender participation, and testosterone-based eligibility policies each raise their own different medical, legal, and policy questions, and the governing rules vary across the sports. So the data gaps at the elite level, combined with the stigma and discrimination risk of testing, mean that disputes in this area are likely to continue and intensify. Then third, we have the commercialisation of sport, as I mentioned previously, and within that, I think specifically 2 key areas, so spending controls and sponsorship. On financial fair play, whether it is the Premier League's transition from PSR to the new SSR and SCR framework, salary cap mechanisms in rugby and Formula One, or the challenges of policy-related party transactions and offshore payments, financial regulation in sport is becoming more sophisticated but also more contested. The more complex the rules become, the more disputes they generate. And I'd probably add to those 3 a cross-cutting theme, AI and technology. It's almost a given these days that AI will be mentioned when it comes to, looking forward and thinking about risks. But I think there are a few things worth mentioning in the sports context specifically. Data sets used in performance analytics and scouting are likely to attract database right protection, where there's been substantial investment in obtaining, verifying, or presenting the contents. Trade secrets are also emerging as a candidate right for protecting AI algorithms and proprietary data sets. Then there are broader data protection questions. The UK GDPR and the Data Protection Act 2018 apply to the processing of personal data, including health data, biometric data, all of which are increasingly collected in elite sport. To add to that, there's also an emerging question about who legally owns an athlete's real-time biometric and performance data. As sports analytics, AI content generation, and betting data feeds explode, frameworks like the EU Data Act are going to force the industry to grapple with this in a way that it hasn't had to do before. So as AI tools become more embedded in performance analytics, anti-doping investigations and decision-making, the potential for disputes around data right, algorithmic fairness, and IP ownership is significant.
And finally, just to round things off and to close up, what is your key message to litigants involved in these disputes?
I think to summarise, the sporting context is becoming more regulated, more commercial, and more complex, and the disputes landscape is evolving to match. And what we're seeing is a real convergence here. So statutory regulators, competition law, employment tribunals, and the commercial courts are now all actively engaged in an area that was, until relatively recently, left largely to governing bodies to manage on their own. For anyone in this space or advising this space, the practical message, I think, is to probably invest in governance, documentation, and early advice, because the cost of getting it wrong is obviously rising more significantly.
I think just a question of looking at what's going on in sport, really. Increasing commercialisation is going to lead to more disputes that you commonly see in the commercial sectors, other sectors. So simple example would be the more private capital invests in sport, the more likely it is we'll see sort of private equity style shareholder disputes play out in the sports sector. I think increased regulation is a particular area to focus on, particularly, the role of, in football, as we learned from Solomonic's recent update saying that football is the most popular dispute in the courts, I think seeing how the regulator approaches life is a very significant development to keep an eye on. And I think generally just adaptation, sports constantly moving just like the rest of the world is, and being litigants, we need to be flexible in how they approach issues and try and anticipate risks as best they can. I mean, one trend that we are seeing in that respect is sort of my side of the legal business being involved when it all goes wrong. Increasingly, we've been brought in when deals are being structured or when parties are looking to undertake a particular merger or acquisition. Taking that advice earlier and managing risk in advance is likely to be a more productive way of doing it than having to spend more at the back end when something goes wrong. So those sorts of issues, I think, good risk management and sensible planning it's always going to be time well invested, basically.
I think there will be more disputes, as I say, in sport. I'm hopeful also there'll be more mediation, there'll be more settlement, there'll be more dispute resolution as well. I think any stakeholder in sport is interested in seeing less litigation, less money being spent on lawyers, less fighting between parties. And so I think as well as new bodies or existing bodies being engaged more to facilitate disputes, I think it's important that we have appropriate mediation and dispute resolution bodies to try and avoid litigation as well.
Thank you all so much. Some really valuable insights there. I'm sure our listeners will be very, very excited and interested to hear what you guys have had to say. That brings us to the end of this episode of Litigation in Practice. If you'd like to explore more data-driven insights on disputes and litigation trends, you can find out more about Solomonic on our website. And thank you again to our speakers for joining us. It's been an absolute pleasure. Thank you for listening, and follow us on LinkedIn to stay up to date with any of our future episodes, and we'll see you soon.